Good evening and welcome back to another episode of Epic Understanding. I am your host, Coach Erica Love. I have back with us attorney Max Elliott, and she's been doing a marvelous job just helping us understand how to build generational wealth, how to make the law work for our legacy. And she's back again tonight to help us, out just one more time. I'm so excited to have her here with us. Welcome, Max. How are you?
I am doing well. Thank you so much, Erica. I just so appreciate the opportunity to share knowledge with your guests, with your audience, and share what I know, the little bit that I know about how to use the law to create generational wealth, how to preserve it, how to build it within the capacity that I work in as an estate planning attorney. So thank you so much again, much appreciated.
My pleasure. Now, I should say this. We have several new partners as of tonight. So this may be your first time seeing Max Elliott, but I'll just tell you go to the YouTube channel and pick up on some of her previous episodes. They are fabulous. But tonight, you are going to help us cover a few things: trust, deeds, fiduciaries and beneficiaries. You have a lot of stuff you're going to help us out with tonight.
Yes, I just wanted to, first of all, I wanted to kind of revisit what we discussed the last episode, and I really want to tie it together and bring it home with respect to trusts, and then also discuss, like you said, other mechanisms, other kind of provisions that help create, preserve, and build generational wealth within the parameters of the law, and especially with the idea that one wants to avoid probate, which in
Mm-hmm.
Illinois and in New York and many other jurisdictions is a very lengthy and costly process. So that's what I wanted to accomplish tonight, my last evening with you.
Okay, so let's just get right into it. Trust and deeds, how do they tie together?
Right. Okay. So first, let's talk about a couple of different types of trusts. One is the revocable, or what people call the revocable living trust. And then the other one is irrevocable or irrevocable. So I like irrevocable. The revocable living trust is actually the trust that allows you to build wealth during your lifetime, because it allows you to title your assets to the trust while you're still owning those assets. And because you still own those assets, you're not taxed on designating on your beneficiary designations, right? Because it hasn't happened yet. You're still around, right?
Okay.
So that's really important. An irrevocable trust is one where you have designated beneficiaries and you can still be alive, but you have designated beneficiaries. You have provided gifts to them in that trust. And as the assets in that trust appreciate, they're also taxed. So, unless it's a life insurance trust, and I'm not going to get too granular about that, but that is a completely different trust. Now, most revocable living trusts become irrevocable, so they can't be changed when somebody passes away. But then beneficiaries receive their inheritance, and generally there's no tax issues. So asterisk, I'm not a CPA or a tax accountant, so please talk to your tax professional with respect to that. Now, a deed. Let's say you own a home, you own a condo, and you want to make sure that upon your passing, that your property does not become subject to probate, that lengthy, costly court process. As your trust is being established, or actually kind of like right after you've signed everything, the deed to your property is changed. There's another deed that's prepared, and that deed actually transfers your interest into the trust. And in so doing, it avoids probate for your beneficiaries.
So I have a question. Would that be a quick claim deed or is it a different type?
That's a good question. That's a question folks often ask. So let's talk about deeds then for a second. So a quit claim deed is a deed whereby you can transfer property interest, and there you don't have to do a title search. You don't have to do any kind of investigation with regards to ownership. So when you use that type of deed, whatever problems there may be with the title, whatever kind of problems there may be with the ownership, the person who receives that deed, so who gets that property, is going to have to deal with. And so because of that, we generally don't use a quitclaim deed for trust. It's easy, most people use it, but actually credible and experienced estate planning attorneys do not. We
I'm
use
so
what's called,
glad. I'm actually so glad you said that because I was concerned if a quick claim deed was going to be used, because once you go to sell that property and perhaps there's a lien or just an issue with clearing the title, because sometimes that happens. It doesn't mean there's actually anything wrong. It just means that the title is not clear. You will have to deal with that at that time. And sometimes entities go out of business, or they just sell your loan, and then it becomes almost impossible to get a clear title.
yeah, it's quite yeah, you're referring to what is known as quieting the title.
Mm-hmm.
And it's the reason why we don't use quitclaim deeds. We use what's called warranty deeds. And
Okay.
so a warranty deed basically states that the title is clear, that the investigation has been done, that there is no problem really with the title.
Mm-hmm.
And so upon a beneficiary, for example, receiving property that is subject to a trust, because the deed is titled to the trust, they don't have an issue with respect to that title, with respect to that deed. Now, one of the things that we do have to keep in mind is just because you have a title doesn't necessarily mean your name is on the mortgage, right? And so we have to think about that in terms of estate planning. So this
Mm-hmm.
is where some of the information that we talked about last time can come into play. So if you have life insurance, do you want to use that life insurance to pay off the mortgage so that your beneficiary inherits that house basically, mortgage free, because they just take the life insurance and it's stipulated in the terms of the trust that this life insurance shall be used to pay off the mortgage. And
Mm-hmm.
there you have a beneficiary, you've provided a child, a grandchild with a home that has no mortgage on it.
That's
So
wonderful.
yeah, it's very helpful. But again, you just have to we have to make sure that those terms are actually in the trust, and that we use the appropriate deed and also the appropriate titling, right? Because, for example, if let's say a married couple own a
Mm-hmm.
home in joint tenancy with rights of survivorship. So without a trust, without a will, without anything in place, what that does is, upon the passing of one spouse, the surviving spouse inherits the home without having to go through probate. But the issue is, A, what if unfortunately both of them pass away? And
Mm-hmm.
then B, if they own it in joint tenancy and somebody places a lien on one of the spouse's interest,
Mm.
and if that spouse dies, then that lien carries through, unless there are terms in the trust to stipulate otherwise, right?
And so,
And go ahead.
what if there are multiple children? Okay, so mom and dad pass away.
Mhm,
Um, things are not necessarily in a trust.
mhm,
Okay,
mhm,
and there are three children. How
mhm.
does that work?
So you're talking about if there's property and it's not in a trust and
Yeah.
mom and dad
Yes, a
pass
home.
away,
A home.
die,
Yeah.
right? So then what happens is those children are looking at the court process known as probate. And just let me explain to you what probate looks like right now. In Illinois, it's about 18 months long. In New
Mm.
York, it's about 12 months long. For six of those, the first 6 months, assets are frozen. So one cannot obtain any of the distribution until those 6 months have passed. And those 6 months are there to allow creditors to place a claim on the estate. So any and all just claims have to be addressed before any distributions are made to the heirs. So and then if there's nothing, like you said, no planning in place, the laws of descent and distribution come into play, which is basically the laws that state who gets what when somebody dies. And so, for example, in Illinois and in New York, there would be a third, a third, a third, right?
Okay.
After all debts are paid. Now, one of the really interesting issues with that and it's something that trusts actually deal with, is what if one of the children is a half sibling, right? A
Mm.
child born out of wedlock, a child born from a previous marriage, and the intent was not necessarily for this child to inherit from one of the spouses, from the spouse who's not, from the parent who was not their biological parent, right?
Mm-hmm.
Well, unfortunately, in Illinois and in many states, a half sibling is equal to a full sibling. So that
Oh,
sibling will inherit one third of the estate, even though they were only maybe supposed to get intentionally 1/6.
wow. So there's a question here. It says, so would the trust list all the children to share equally?
Oh, I see that. Thank you. Thank you, Rhonda. And just a disclaimer, I don't practice in Texas. I have clients in Texas, but that's because they have Illinois property. But just so you know, so with that little disclaimer in mind, in Illinois, and this may be the case in Texas, I don't know, but with respect to a trust, you do not have to designate equal distributions. And so that's
Okay.
something that I come across a lot, especially so, for example, what if one child is extraordinarily affluent, right? If a
Okay.
child is affluent and the parents say, you know what, they have Rihanna money, we
Ah,
need to get, we need to take care of our other two children. They can say, you know what, here's a special token. You have Rihanna money. We want the rest of our estate divided in half between, your brother and sister. So with a trust, you can dictate the terms of the distribution any way you like.
okay. Excellent. Excellent. Okay. So let's talk about fiduciaries and beneficiaries. Oh, wait. What did you say? Call it? Yes, that's right. Fiduciaries.
Right. Okay. So, fiduciary and yes, beneficiary designation. So we kind of talked a little bit about beneficiary designations as who gets what when you die. Fiduciaries are critical because they are the ones who distribute the assets. They're the ones who wind up the affairs. They're the ones who pay the debts. They're the
Mm-hmm.
ones who do the accounting, right? And so it's really important to choose the appropriate tax, I'm sorry, the appropriate fiduciary in
Mm.
order to administer your estate. So, for example, in a trust, that would be a trustee. With a
Mm.
revocable trust, you are the initial trustee because it's still all of your own property. However, once you pass away, or if you become incapacitated, whoever you have designated as a successor trustee steps into those shoes and then begins to manage the affairs of your estate. Now, it's really important not only to designate somebody who you know will be trustworthy upon your passing, but I just mentioned if you become incapacitated, your
Mm-hmm.
successor trustee can then step in to take care of you with
Okay.
your assets, right? And
Mm-hmm.
what's really important there is that you need to make sure that if you choose someone who's also a beneficiary, that they
Mm.
understand that the assets that they are administering during your lifetime are solely supposed to be for your benefit, unless the trust stipulates otherwise.
Mm. I see. So basically, you have to make sure they understand that all of this money is not meant for the new Maserati. It's,
Exactly.
I got it.
Exactly. There again, that's the beauty of a trust is that you can stipulate almost whatever you want in terms of distribution during your lifetime, during incapacity, and also upon your death. So, if during your lifetime you were a philanthropist
Mm-hmm.
and you gave, let's say, 10% of your income every year to specific causes, you can stipulate that even if I become incapacitated, as long as it does not jeopardize my care and my comfort, my trustee shall continue to donate to the causes and support the causes that I routinely supported during my lifetime or
That's
while I
fabulous.
was not incapacitated.
I think we need to create more trust fund babies. I'm just saying. I think
I know,
trusts are
right?
magnificent. They are. They just
Right,
are.
exactly. No, and the great thing about this is with this kind of mechanism, all of that happens and all of that can occur without the court coming in. Thank you, Rhonda. Without the court coming in to kind of like say who gets what and how it should be done. So if a trust is done properly, and if a will accompanying that trust is done properly, there's no court. So the attorney's fees that will be used will be those that for establishing the trust and maybe a little bit on the back end for providing some guidance to the successor trustee. And that's it, not lengthy court fees in the tens of thousands of dollars that are attributable to probate.
That's just magnificent. And I just want to say, for those, parents or loved ones who don't want to think about it, they don't want to plan, think about this. Do you want to give your money away to the state and the government for their own, I don't know, behests? You know, Because
Mm-hmm.
really, that's what you're doing. That is what
Mm-hmm.
you're doing. It's literally just kind of saying, here, government, take my money if you don't plan
Oh,
ahead.
oh, absolutely. We call them unintended beneficiaries, right?
Mm-hmm.
Because, for example, in Illinois, the fees for probate just increased. And so we're talking just to get into court, not to actually open the estate, but just to get there is going to cost $500
Mm-hmm.
just to get there. And then again, like I said, it's a more than a year long process, and generally you're talking at least 20 hours of attorney work, and that's
Mm-hmm.
hopefully if you have only one attorney involved. If a challenge comes, then you're talking two attorneys and
Mm-hmm.
double the fees and court time and so forth. So, and then there's also what is known as a bond, which is an insurance premium that the court appointed administrator must pay in order to ensure that they don't run away, that this administrator doesn't run away with the assets. And they have to pay that
Wow.
fee annually until probate has ended. And so what if, um, what if the court appointed administrator doesn't have that bond? Well, then somebody else
Okay.
has to be appointed, right? And what if the siblings don't, and they are to get reimbursed, but what if the siblings don't want to reimburse them? What if the beneficiaries are like,
Mm.
no, 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 so
No. And you just never know. You never know what kinds of things are going to come up after the fact. It's important to, plan this out. Now, as we wrap up, I still want to talk about transferring upon death payments and
mhm,
instruments.
mhm. So there are mechanisms other than a trust. And so a transfer on death instrument known as a TODI in Illinois, it's known as a transfer on death deed in other jurisdictions, is another probate avoidance mechanism. And it's generally used for people who are, as one would say, house rich, cash poor. And
Oh,
hmm and so what it does, it allows you to transfer, it allows you to designate who is going to receive your home, your property. And the law was just changed in Illinois, so it just doesn't apply to residential property or primary residences. Now it applies to all types of property, which is really helpful. But it allows you to designate who will take your property upon your death. Let's say all you have is a bank account. You're let's say you are in your wealth accumulation phase, and you put every little bit of money you had into purchasing your home, and so now
okay.
you have a bank account and you have a little IRA. You can designate beneficiaries for for that account, for that IRA. You don't have much else, just personal belongings, but you have your home. And so all you have to do is have a transfer on death instrument or a transfer on deed uh, prepared, and it functions as a probate avoidance mechanism upon your death. What's really interesting about this particular mechanism is that I've also used it with folks who were cash rich and house rich,
Oh,
because with trust, because let's say you own a home and you also have significant assets and you're about to refi,
okay.
and you want your home to, you want to avoid probate in the event something happens to you, and so the refi process 30 days, 60 days, right? You're like,
Right.
I don't know what is going, I'm just paranoid. So is there something we can do? Yes. During this refi time, we can have a transfer on death instrument prepared and used as a hedge. So while your home is out of trust, it's still covered by a transfer on death instrument or deed. And then once the refi is over, we revoke the deed and put your home back in trust.
Very nice. So
Mhm.
really, it's just important to be strategic and think about what we're doing with our valuables. You know, our home is normally our biggest asset, um,
Mhm.
but the jewels, if you have any of those things, cars, all of those things, it's valuable.
Mhm.
Um, and we just want to pay attention to that. Now, before you go, because I know this
No,
is an important thing,
that's okay.
let's talk about jurisdictional issues because it makes a difference, right?
It really does. And even before we get there, you mentioned jewels and cars and things like that. And I want to mention something that is on a lot of people's radar, but they think that it's just kind of out there. And that's digital currency. Rhonda, keep your question up.
Ooh,
I'll get I'll get to it.
okay. Yeah,
I'll
yeah.
get to it in a second. Okay, I'm just reading it. Just keep it up there. So
Okay.
let me talk about digital currency, right? So we're talking Bitcoin,
Yes.
Ethereum, right? And
Uh-huh.
these currencies are coming into the mainstream. I mean, grocery stores accept them. We see, coin flip, I think, being advertised on television.
Oh,
And
wow.
and the interesting thing is, currency is a misnomer. They're not actual currency.
Okay.
Okay, digital currency, virtual currency, whatever you want to call it, is actually defined differently by our federal agencies. The IRS taxes it like property. States don't look at it or consider it as property. The SEC does not consider it as a security, and the CFTC does not consider it as a commodity or future. So,
Okay.
what are we talking about? And how can you actually transfer this digital asset to a beneficiary? And that's a whole other episode, but I must let folks know that you definitely need an experienced and knowledgeable attorney who is knowledgeable in how to transfer this currency and is knowledgeable about digital estate planning, because you just can't transfer it into, okay, I have a wallet on my phone and my Bitcoin is on my is in the wallet on my phone. So all I have to do is make sure that, whoever, wherever I am, or whoever gets my phone, can access it. It's not that simple, because there's also a digital access act that stipulates how somebody can actually access your computer, your phone, etc., without becoming liable in terms of criminal acts. Because if
Oh
you
my
access
goodness.
someone's computer, if you access someone's phone without having the proper legal authority to do so, and that language in some kind of instrument providing you with that legal authority, you have actually committed a criminal act.
Mm.
So those you were talking about, the what I consider traditional assets, and I'm like, there's a lot of other stuff out here. What about NFTs, non-fungible tokens, right? So
Wow.
there's a lot of stuff out here.
You know what? I think we're going to have a show on that kind of stuff. You know, every time we talk, there's just like more and more and more and more. It piles up.
Well,
Let's,
yeah, just look into it. I think it's fascinating. I've talked
it is.
about digital estate planning for a long time. So, and also, like, what if somebody gets a reservation for a SpaceX flight, right? So, how do you deal with that?
Yeah. Oh,
So
wow. It
So,
is.
but
It is fascinating.
Rhonda has a great question, and I just want to read her question. In establishing a trust, would all beneficiaries for 401k stock accounts and life insurance policies be changed to the trust? Asterisk, I am not a financial planner or a financial advisor, and you bring up a really good point with respect to 401k or retirement assets. I
Mm-hmm.
don't know if I mentioned this last time, but in 2020, the Setting Every Community Up for Retirement Enhancement Act, also known as the Secure Act,
Mm-hmm.
passed. And the Secure Act, is supposed to help folks, establish retirement and establish a good retirement nest egg. But one of the things, thank you, one of the things that it did was upended estate planning world for like 70% of our clients because it eliminated the ability for individuals to designate anyone they wanted as a beneficiary on a retirement interest who could then stretch it out over their lifetime, right?
Wow.
So our retirement interests are used, we pay
Wait, does
into
that
it during our
still include
lifetime.
annuities? Is that
Hmm?
for annuities as well? Is that for annuities as well?
Yes. So you cannot, so any plan that falls under ERISA, any annuity that falls under ERISA, so that's 401ks, 403bs, 401a, for IRAs, Roths. So what happens? We used to say, okay, well, I have a significant retirement account, right? And I'm traveling all the time now, and I have a 17-year-old. Okay, well, my 17-year-old will be the beneficiary, and then my 17-year-old will be able to stretch it out over their lifetime. I'll make sure that that happens. They can stretch it out over their lifetime. Well, no,
Mm-hmm.
that 17-year-old, if you unfortunately died while that 17-year-old was still 17, they would have 11 years total to withdraw everything. So let's say you were affluent and or let's say you made a lot of money in Bitcoin, right? And you have $500,000 and you were able to trade it and so forth. And so in you had $500,000 in a retirement account. That meant that your 17-year-old would be getting about $50,000 a year. You want to put $50,000 in an 18-year-old's hand?
Mm-mm.
Mm-hmm. And so, yes, yes, yes. And so when the Secure Act passed, it actually it actually eliminated that ability, except for five what we call exceptions, eligible
Mm-hmm.
designated beneficiaries, and I'm not going to get too granular, but one is a spouse, so that's good.
Mm-hmm.
But a spouse is generally the same age you are, so if you have a kid or kind of around there, right? So if you have a child,
Right.
then the other exception is a child who is a minor. But once that minor reaches 18, they only have 10 years. And so
Mm-hmm.
again, do you want to put $50,000 a year in the hands of a 21-year-old or a 22-year-old? No. Right? And so then the other one is a chronically ill or disabled person. That's absolutely understandable. Stretch it out over their lifetime. That works. And then the other person is someone who is not more than 10 years your junior. So if you're not married, this is a loophole I found. If you're
Mm-hmm.
not married, you can leave it to your significant other and they can stretch it out as long as they're not more than 10 years your junior.
Wow.
So if you're 40 and they're 30, you're just in there. If you're 40 and they're 25, that's not happening.
All
So,
right. May December relationships.
right, exactly. So there are now trusts that are we're using to address this Secure Act issue, but it's not completely curable in all instances, even with a trust. So
Oh my
that's
goodness.
where a really good estate planning attorney can be very helpful.
Oh my goodness. You know what? You gave such amazing information. I'm so appreciative of you. My mind is twirling. You know what happens to me. I just get to thinking and wondering and wanting to unpack this even more. I
Mhm.
can't wait to have you back so we can, I don't know, just discuss this. Who would know that this is so interesting and fascinating?
Yes, I mean it's really it gets to it can be as simple as someone inheriting a home because a loved one has passed away, a parent has passed away, they're the only child, the parent was a single, single parent but owned a home, and the child is like, "Oh, great. Okay, I can just take over the mortgage payments, or the home is paid in full and I don't have to worry about anything."
Mm-hmm.
Until they go to refi the home. And
Mm-hmm.
then the child is like, but wait, my mother passed away 2 years ago. I've been paying the mortgage. Why can't I refinance this home? Because you don't own it. What do you mean I don't own it? Because you don't own it. Your name is not on the title.
Wow.
You don't own it. So you have to go through probate, right? It's as
So
simple as
so
that.
will a quick claim deed work in that situation?
Yes, but do you really want to put a child on a deed, especially, if the child is older, right? If the child is older and has exhibited responsible, stable life, sure, maybe 40, 50 years old. But then again, there are some 40 and 50-year-olds who have financial troubles.
Mm-hmm.
So I always caution people about putting loved ones on a deed, because once you do that, their creditors can start attaching liens on your property, right? So
That's something else.
that's where a transfer on death instrument, or a transfer on death deed would come into play. But this is information that, folks just have. It's like, oh, I get the house. Well, yeah, no, you don't. Not unless there's some planning done.
Got it.
Or yeah, you do, but you can't do anything with it because there was no planning done. It
We've
can
got
be
a
as
plan.
simple as that,
We've got
or
a plan.
as complex as the Secure Act saying, yeah, no, that big retirement chunk, your teenager, if something happens to you, your teenager's got 10 years and they get it all. It cannot go to a trustee. It goes directly to them.
Oh my goodness. Now this might sound like an out of the blue question. You might say, "Oh, Erica, I cannot help you with that." But this goes actually into the next show that we're having on this network. Okay, at right at about 8:30. Okay, R. Kelly has recently been convicted,
Mm-hmm.
and he has some wealth.
Mm-hmm.
I'm sure he wants his wealth to go to his children, right?
Mm-hmm. Mm-hmm.
If he has it in a trust, or if he puts it in a trust now, let's pretend he does, he didn't. But if he puts it in a trust now, oh, I
Mm-hmm.
see your face. is, is it is it still protected from the people who may be suing him now?
Nope. 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 Nope.
Oh.
There are there's that issue, and there's also the other issue that we talked about but not in this context, and that's the
Mm-hmm.
state. And
Mm.
on occasion I get queries from individuals with loved ones who are incarcerated, and they want to leave their loved one an inheritance. And what I have to tell them is your inheritance will be used to repay the state for room and board for your loved one's incarceration. And so with anyone facing incarceration, that is a creditor, and the state, and depending on whether there are also federal charges, and I think there are, the federal government takes before anybody else.
Oh my gosh.
So the federal government will have their hand in the till upon his passing. I'll get to the umbrella policy. Oh, Rhonda, just go ahead, girl. I'll get to the umbrella policy in a second. But the state will have their hand in the till if something happens to him. The reason why he cannot protect his assets, or someone facing incarceration cannot protect their assets by using a trust, is the same reason why an elderly person who knows that, you know, maybe they're going to need a lot of medical care that they can't afford, so they're going to go on Medicaid. It's the same reason why they can't transfer their assets to a trust either. It's called the Fraudulent Conveyance Act. And for the IRS, within 3 years of transferring assets to a trust, if there is a lawsuit, and if you know there's a lawsuit potentially coming down the pipeline, that trust will be unwound and those assets will be reachable. That's for kind of like this context. With I think I'm going to need to apply for Medicaid, let me put everything in a trust. Well, there is a 60-month, 5-year look back period for Medicaid. So that's not going to happen either. So either way, it's considered a fraudulent conveyance. It's going to get unwound, and whoever is due a payment, due a judgment, will get it. But they'll get it after the government gets it.
Well, all I can say is I cannot wait to have you back. Shall I say this was juicy?
Oh, thank you. So Rhonda asked about umbrella policies, and I want to get to that because she's been very kind asking questions. So umbrella policies, they do cover your assets to a certain extent, right? Because I tell people, and we talked about this during the last program, do not put a residential income property into a trust. Don't do that. Put it in an LLC.
Right.
And that LLC should have an umbrella insurance policy on it. The question then becomes, if there's a slip and fall, how much is your umbrella insurance policy going to pay out, right? If somebody has a horrible slip and fall, and they let's say they were going to be a doctor, and now they have a TBI, a traumatic brain injury, and that means the money that they've invested in going to medical school, that means their career going forward is now gone because they slipped and fell on your property. Is $1 million policy going to cover it? I don't think so. So that's when other issues and mechanisms must come into play. Okay.
Amazing. You know what?
Well,
I'm going to rewatch this because there is so much to unpack, but I usually do. I feel like I need a pencil and pad, you know.
well, thank you. I really appreciate it. I always enjoy sharing information, new laws, new laws. The law happens all the time, and especially in this space, it's really interesting. It's happening more and more, and as technology advances, so does estate planning in order to try and capture all of that and to pass on that wealth. So it's up to me to pass on that information, and I just really appreciate the opportunity to do so.
Awesome, awesome. Just thank you for making us smarter. Thank you so much. We appreciate
Oh,
you.
oh no, you're quite welcome. And if anybody wants to, you also asked this last time, if anybody wants to kind of chat with me or get more
Yes,
information, just Google me.
yes.
Just
You
Google
know
Max
the last
Elliott
question, don't
Law.
you?
Just
So
Google
what is
me.
it? Say it again.
Max Elliott Law. Just Google Max Elliott, two T's, Law, and you'll find me. Okay.
Excellent, excellent. Thank you so much. We'll see you back soon.
Okay, thank you, Erica. Bye bye now. Bye,
Bye bye
everybody.
for
Bye,
now.
Rhonda. Thank you.
Excellent. Bye bye.